if a court were to take your suggestion and offer just a paragraph explaining why the court was denying a writ petition, it wouldn't necessarily have precedential effect. And I guess that's because it's not a constitutional cause. Would that be? It just reminds me of this phenomenon that people have been calling the shadow docket of the United States Supreme Court, where these things are happening off of the more heavily watched docket, just on motions and things like that. This would tend to create something like a shadow docket in our own California appellate system, would it not?
Well, look, I wrote a column last year about the distinction between published and unpublished decisions, which didn't exist when I started practicing. They were all published. And sometime in, 1970s, the court decided that there were too many law books. They were weighing down the shelves of the judges, the law firms, and they cost a lot of money. I mean, this is before computers and the internet. And so we're going to limit the number of decisions that are precedent so we don't have to clutter up offices with these books. But since then, now that everything's online, Westlaw and Lexis and everything's published, right? They're published online. And the other way of using the word published in actual book form, nothing's published, right? So the two terms are totally archaic. If instead you do something more accurate, like precedent and non-precedent, it's semantically correct, but it's a bad idea. I think you got them all online. They all should be usable as precedent, because what is law? Is law what the courts say it is, or is it what they do? Now, if they say they're doing one thing in a so-called published decision, and you were to look at 20 unpublished decisions and find out they're doing something different, what would you advise your client? What is law? Law is what they do. Let the public see what they do. Let them use it as precedent. It may impress the court and affect their decision, or not. Or they can say all those so-called unpublished decisions are wrong. That's okay. But use the term shadow law. This is shadow law. It's really law, but it's not only in the shadows, it's totally in the dark. And to me, that just doesn't make sense. All right. Now, some of the appellate justices will come back and say, well, if they're going to use it as precedent, we have to put more work into it. We got to make it better. Is that a bad idea? I don't think it is. The Ninth Circuit has a gimmick called memorandum decisions, which has been proposed in California. We don't have it yet. I don't like them. I don't like memorandum decisions. I've seen some of them in cases I've been involved in, and they're lousy opinions. They're brush-off opinions. They don't thoroughly examine it, and they come to the wrong result sometimes. What are our courts there for? To provide justice to parties. And granted, we should provide more resources to the court, but they got to get it right.
Yeah, no, I agree with you completely. That's a good observation. That law is what the courts do, not just what they say. When they, I've heard commentators mention that the courts can cite to a law review article. They can cite to a law student spouting off his or her opinions in a law review article. They can cite to a blog post, but they cannot cite to what that very panel did a week ago in an unpublished opinion. And that just, I agree with you. That makes no sense to me. And
think about an example where the court comes down with some test or breach of contract or tort or something, and it's a vague test. It's not a litmus test. It's something you consider a number of factors, blah, blah, blah. It's a lot of tests like that. All right. What do you do with that? How do you use that to predict what a court's going to do next? The only way is to see what they do. Now, if you got a number of unpublished decisions where they apply that test consistently one way or the other, that's law. That tells the public what they should be doing. And what, you can't cite that? That
Right.
doesn't make sense to me.
Right.